Hello again. I am back making another video. Today's video is going to be 3 tips for handling family court cases with our abusers, and just a few. It's just a few tips, but generally speaking, the tips that I have compiled are going to be able to, if not, because nothing's always said and done with family court. Unfortunately, you're kind of bound to that for 18 years or however long it takes for kiddo to kind of process out of the family court. I know in some states that changes. Some states, I believe they're able to, I think the youngest I've seen is like 11 years old, where the kids are able to actually say where they want to go, or who they want to live with. And as far as I'm aware of, or what I've heard, is that those statements and decisions are taken pretty seriously by judges, but I've been surprised by far less in the family court system, so it really just depends. Um, okay, let's get started. So, first tip is understanding the family court's limitations in dealing with domestic violence. So, we have to consider our limitations, and again, I always bring my notes with me, but we have to consider our limitations before we decide to open up a family court case. And a couple of these very specific parts, in particular, we need to understand that unless we get a private attorney, which most of us can't afford, um, we'll be responsible for the preparation of evidence and presentation of the case in court. Again, this is family court. This is not criminal court. Criminal court, generally, especially with domestic violence, most cases are taken by the state in which the offense took place. So, a lot of times, victims of domestic violence won't really have to do anything. They'll just be served the, occasional subpoena, or, their phones requested, stuff like that. Um, anyways, so with us being responsible for preparing our own evidence and documentation and basically designing our own cases, we need to go into this with the battle mindset. This is not, a lot of times when we get out, we'll get out of the abuse, and our brain almost shuts off because we're out. We're safe. We're out of there. We have survived. We've ripped the band-aid off. We're not only are we dealing with the constant onslaught of messages and more harassment, because leaving is the most dangerous time for domestic violence victims, but now we're internally going through our withdrawals from codependency, or with our anxious attachment styles. Our life is kind of quieting down, but we have no idea how to handle the quiet, safe space. So there's a lot of moving parts happening, and in order to sort of get through that, we have to present our case accordingly to the judges. So, and one thing that abusers do get is the opportunity to present counter accusations. So a lot of times they will present these counter accusations, oftentimes saying, some things that I've personally heard, I think, were somewhere along the lines of them holding absolutely no accountability, but also blaming my own abuse on me. So a lot of times, maybe the bedroom life was brought up, or consent was brought up. Just really, the abuser just trying to be really, really clever, and, in my opinion, quite desperate, as far as like getting away with certain things like strangulation, things like inappropriate language. All those things can be essentially chalked up and very, very minimized. So we have to go into this being prepared, especially in family court. Those are things that we're going to have to substantiate. If we know in our heart of hearts that the abuser is not safe for the child to be around, or be involved with, or anything like that, that's up to us to prove it. We have the burden of proof, is what it's called in court. But we have the burden to provide that proof to the judges, to show them why the children involved would not be safe with them. And part of that burden of, providing the proof is they are within their human rights, their civil rights, to argue that, and also simultaneously kind of project whatever accusations they may have been stockpiling. And I think, as a good note, as a good sort of side note, I would recommend being prepared for all of your accusations to be essentially reversed. So I would recommend if you're coming up there saying, that, let's see, what's a good example? Maybe saying that all of your, some items in the home were smashed in front of the children, which by definition is domestic violence and child abuse. But let's say that that's your accusation. Well, then it might be rebutted with something similar to, she broke those when she was mad at me because I didn't take the trash out, which maybe there's portions of that accurate. So maybe we were upset that the trash didn't get taken out because they said that they were going to take it out and then they didn't take it out and then they gaslit us about the trash not being taken out. And then, to take one further, they smash all of our stuff because we are upset at them, which does not sit well with abusers whatsoever. So they'll just like make a quick, they might even go so far as, and this is something that I've seen, where they will break stuff on their own and then take pictures of the broken stuff and then present it to court saying that you broke the items. So especially in family court, it's always best to be the first whistleblower in the situation and just file, because the first one up, that's our job. Our job is to provide the proof for the judges. And a lot of times when we're accused first, we're kind of fighting that uphill battle, and we may or may not be already a little bit behind. It just depends on how clever the abusers are. And it also depends on how prepared us victims get before courts and before court hearings and stuff like that. So anyways, yes, first tip, be very, very prepared for those accusations to come. Those are family court limitations. So part of the issue with the domestic violence as far as family court goes, and where I believe that our system is behind on, is allowing domestic violence abusers several chances to, rebuttal their case, argue their case, justify their standpoint, whatever. But that's a family court limitation, so you should be prepared, to counter their accusations as well, which will happen. It always happens in domestic violence cases. They want nothing to do with accountability. All right, let me move on because I keep digressing. So the second tip is, if there is going to be a criminal case against the abuser, we need to do everything we can to maximize the strength of the criminal case. So part of doing this is making sure police have all the evidence they need, that the report covers to all that evidence are uploaded correctly. If your court is old school, a lot of times they'll just take copies labeled in handwriting because it's super janky. Exhibit A, B, C, such and such. I know in Colorado you can upload everything electronically, which is also nice. You can also email serve people, which is very, very convenient. And a lot of times it's very, very simple to get things uploaded and admitted into your court case pretty simply. But again, that portion of the process varies from state to state. So like I said in an earlier video, always be at the courthouse. If you are going through a family court case and you're pro se, which means without an attorney, always be at the courthouse, bugging those clerks, asking the questions, finding the resources, meeting attorneys, doing whatever you can to make yourself more knowledgeable, because this is going to be your battle for the next however long. Could be 18 years. So just make sure you throw your all into it. You need to make sure that the DA files adequate charges as well. This is, again, if the state is pursuing charges, and make sure that in part of the family court system is initially you'll open up with a test, basically you're testifying as far as why you feel whatever is a problem. And part of that is just having all your ducks in a row. If you got to write it all down with bullet points to keep your priorities straight, because the word salad and the gaslighting and all those abusive behavior techniques that these people have grown and learned and adapted to, it doesn't stop just because you're in front of a judge. No, ma'am or sir. It will continue. And it almost gets worse because they do not want people to know how they actually function. So the fact that you've even gone to a third party to get help is very upsetting for them. They're already top tier, stress level red, ready to go. They're going to get everything ready in their mind to make sure that you leave the room feeling like an imbecile, feeling like you weren't prepared, feeling like you lost. They might even go a step further and send you emails later down the road, also talking about how your performance in court was poor and how they just are going to continue to try to isolate you. And it's important to really not pay any attention to that. In family court, they don't really want to see too much back and forth between the parents, anyways. It kind of just bogs down the real considerations, which is the safety of the child and the well-being and best interest of the children involved. So all the back and forth, you really legally you can ignore, unless it's like an actual safety concern. Somebody didn't return the kid, somebody didn't pick the kid up, stuff like that. You really shouldn't even be partaking in it. Per my recommendation, you should be getting your own therapy on board and seeking out your own social support system, and maybe a new career, maybe a change in scenery, something. But again, just keep all that in mind. So organizing your cases is going to be a strong suit for you. If there isn't a criminal case against the abuser, consider opening one by making a report to police about the abuser's criminal acts of any sort of physical, sexual violence, threats of violence, stalking, harassing. And I just want to real quick touch on the basis of stalking. Stalking is oftentimes, in most states, you're going to have to pull up your actual state law. But in most states, stalking is the only requirement that's needed to meet the definition of that word in a criminal case is 2 or more incidents of contact without consent. So if they have, and I don't mean like they sent you an email about parenting, that's never going to hold up in court. But if they showed up twice to your work, or they called your boss, or stuff that obviously has nothing to do with the children involved, that is by definition stalking, and you have a criminal case there. So you can definitely pursue. It may not result in anything, but the more eyes that you get on your case, the better off you're going to be. Because 2 things. The family system, the legal system, they are burnt out. They are tired of hearing it. But the more that you're advocating for yourself, the more serious you are, the more prepared you are, the more knowledgeable you are, the more words you say that they understand, things like that over the long haul, the longer period of time, those all start gradually holding up, and you start getting the answers that you need. You start getting the resources, you start getting the help, you're doing the work, you're showing, you got to remember these people, for the most part, are pretty normal people. They're not exactly out to get anybody, but they can be, which is an important thing to always keep in mind. Even though there might not be enough evidence to result in a conviction, the fact that the police officer has documented the existing evidence and named you as the victim in the crime report, it can always be very, 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 very helpful, not only in family court, but in many other arenas as well. So anything like restraining orders, those need to come up. If you had to call for a welfare check because maybe they threatened self-harming behaviors and you were concerned about them, those are all justified as well. A third tip. Before each family court hearing, we have to inform ourselves as much as possible as far as the purpose of the hearing and the specific question before the court. So knowing the purpose of why we're there. I can't stress this enough. Do not wait until last minute to try and figure out what the next court date is all about. If we don't understand what's happening at the next court date, we have to call the victim advocate, family court office, the county clerk, go down to the self-help law library, ask them about it. Only by knowing what our court date is about can we properly prepare. I cannot stress that enough. And for those of us, me included, with anxious attachment style, right? We want the next step. We don't do well when we sit in the unknown. That gives us too much anxiety. We don't have, plan A, B, and C worked out. Knowing the reason for the next hearing, which is why I always encourage the sole custodial parents to be the first ones to file. Knowing the purpose of the hearings is going to benefit you so much. You're going to walk into that with a prepared plan. If you have your why, then you can have, if you have your what, then you can have your whys all listed out for the judge. And no offense, but if you have all of your reasons for the motion that you filed listed out black and white for the judge. It's going to back our abusers in a hole. It's going to explain your concerns first, especially if you file first. If you don't file first, you have to respond. So that's why I kind of mentioned the uphill battle portion. You have to rebuttal. So all of these, all of these tips and tips and tricks are going to help you. So if you know your why of, what purpose is this hearing, then you can develop your whys as far as what you're concerned about. And then whatever they say during the, time that they get to explain themselves or justify whatever it is that they believe they're doing correctly, even though it's not, it doesn't really matter. It's not really here nor there. It doesn't really matter at all. You laid your concerns out for the judge. If they meet specific criteria, it's black and white. And I know that that's scary. I know our time before hearings can always be very, very scary. Filing motions can always be very, very scary. It's all kind of a bit of a no man's land. But like I said, like many resources out there will continue to say, the more that you study and the more that you sort of, envelop yourself in, the more fluent you become in this second language called family law. And it's a never-ending process, but those are my 3 tips for the day today. I just wanted to get a decent video out there. It's been a minute since I've posted, and I'll keep on top of it. I got school going and stuff too, and kiddos, so we gotta do what we gotta do. You're doing great. Just keep studying, keep doing your research, keep preparing yourself. This is the long haul. The easy road, and that sounds like a terrible choice in words, and it might be, but the easy road was that Band-Aid ripping off, was leaving. That you're now in it. After the Band-Aid is ripped off, it is now game time. Put on your warrior face, stand up in front of judges, call attorneys, bug people, get to know the court clerks, get to know your legal jargon, Google research everything you can. Also pull up Judge Anthony's YouTube channel on family court and fighting the narcissist in front of a judge. He does a lot of really great tips, a lot of really great free classes that you can go to. And then again, don't forget to do your monthly free parenting, co-parenting classes, because we're all about prevention here. So you got this. All right, I'm proud of you.